and welcome to One and All Present. My name is Lakshaya and I am an intern at LEXIS and Co. I am a third-year law student at New Law College, Pune, and the topic for the day is, what is the difference between trademark and copyright? Intellectual property rights, which are often referred to as IPR, is essentially a property which includes intangible creations of human intellect. There are a series of IPR recognized all over the world, and some countries recognize a few more than other countries. But the main area of focus for today is the difference between trademarks and copyrights. This article will aim to briefly clear any doubts concerning the difference between trademark and copyrights. First, we must understand what a copyright and a trademark is to actually differentiate between them. A copyright is a legal privilege granted to authors of literary, musical, theatrical, and artistic work, as well as producers of motion pictures and sound recordings. Names of brands, slogans, brief words, combinations, short phrases, plots, methodologies, or factual information are not protected by copyright. Ideas and concepts are not protected by copyright. As a result, copyright is commonly used to protect the originality of people as writers, printers, dramatists, designers, musicians, architects in sound recording, cinematography, film, and computer software developers. Trademark is a phrase or a visual sign used by a business to differentiate its goods or services from those of other businesses that offer similar goods or services. To register a trademark, the applicant must file a trademark application in the approved format with the competent trademark registrar. Trademarks are commonly used to protect brand names, business names, slogans, and a variety of other things. As we can infer from the above, a copyright is a privilege granted to artistic work and anything that deals with forms of arts, compared to trademark, which is a privilege granted to visual signs used by businesses or brands to differentiate them from other visual trademarks. Both copyright and trademarks are essentially granted to protect the originality of the content from freeloaders. A copyright is a legal term that refers to the protection of literary, musical, theatrical, creative works as well as cinematic films and sounds recordings. Copyright Act allows for registration of software programs, tables, databases, and literary works in the eyes of the law. A copyright is a legal right that grants an exclusive right to the person who created the work. Any person who has a copyright must exercise it responsibly and in accordance with the copyright law. A copyright is given to persons who are creative or who have original work. Writers, poets, artists use copyrights to safeguard their original work. Nonetheless, the source code for the software must be given to the Copyright Office along with the application in order to receive copyright for the software. Individual businesses and non-profit organizations all utilize trademarks. To protect their brand names, businesses' name, slogan, and other items or trademark cannot be used to a concept. An idea or software, a distinctive name given to a concept or a piece of software, on the other hand, can be trademarked. Many businesses utilize their trademark on their product packaging or on the product itself. This protects them from other people using their goods, trademark, or logo. The trademark owner has the legal right to sue anyone who uses this trademark without his permission. The Copyright Office, Department of Higher Education, and Ministry of Human Resources Development are in charge of reviewing and accepting copyright applications. The Controller General of Patents, Designs and Trademark, Ministry of Commerce and Industry, is in charge of reviewing and accepting trademark applications. A copyright lasts for 60 years according to the general rule. In the case of original literary, dramatic, artistic, and musical works, the 60-year period begins the year from the author's death. The 60-year term begins on the date of publication of the cinematography, films, pictures, sound recording, posthumous publications, anonymous and pseudonymous publications, work of government and works of internal organization. Trademark registrations are good for 10 years. After the date of application, by filing a trademark renewal application at the end of 10-year period, the validity of trademark can be extended. This is all for the difference between trademark and a copyright. I hope you understood.